Hi, good evening, everyone. I would like to welcome Dr. Manoj Kumar Sharma, Associate Professor of Law, Rajiv Gandhi National University of Law, Punjab, Coordinator, Center for Business Laws and Taxation, Editor-in-Chief, Rajiv Gandhi National University of Law, Financial and Mercantile Law Review Journal, our resource person of second session of the day 2. He is also working at Maharashtra National Law University, Nagpur, IIM Rohtak, IIM Ranchi as visiting faculty. He has authored 2 books, Fiscal Federalism and Indian Constitution, as well as Expanding Horizons of Right to Life and Personal Liberty. He has written more than 35 research papers and contributed 22 chapters to UGC, EPG Pathshala, and MOOCs, and contributed 10 lectures to UGC Swayam Prabha channel. He has been awarded a research project on the title MFN Clauses in Double Taxation Avoidance Agreements, Identifying Problem and Recommending Policy Solutions by International Center for Tax Development, Institute of Development Studies, housed in University of Sussex, Brighton. He has acted as co-principal investigator for establishing a research center on Shastrik studies in law at Maharashtra National Law University. He has guided 2 PhD candidates and more than 25 LLM dissertations, and he is currently supervising 3 PhD candidates. He has acted as a resource person at various FDPs, workshops, and training programs, and chaired many international and national seminars and conferences at just 35 moot court and other competitions. We are pleased to have you here, sir. Today, he will enlighten us on the topic Artificial Intelligence and Liability Regime.
Thank you so much for generous introduction. Let me start with a few stories, and then my screen is visible, I hope. Is the screen visible?
Yes, sir.
Yes, sir.
Visible.
Yes, sir.
Okay.
Yes, sir.
So I'll start with a few incidents, and then we'll come to the topic. If you Google through that, in 2022, a 10-year-old girl child, asked Alexa, "Give me a deer." And Alexa says, "Plug into a phone charger about halfway into a wall outlet and touch it with a coin. Switch on the plug, touch it with a coin." Now, what would happen if the child sustains injuries due to electric shock? Who would be liable? Amazon, parents, or maybe the software provider? And whether sitting in India, let us suppose this happens in India, would you be able to file a lawsuit on Amazon in US? See another incident of 2015 labeled as a random darknet shopper. Now, here in Switzerland, an art gallery made a bot, online shopping bot. Now, this online shopping bot was given a budget of $100, £100 rather, every week that you can spend. Now, this online shopping bot, named as a random darknet shopper, searched the dark web. And from the dark web, it made purchases of drugs, ecstasy pills, diesel jeans, and then an Hungarian passport from the darknet, and many other things. Now, somehow, sooner or later, it catches the eye of the police, and the random darknet shopper, which is a online shopping bot, that is arrested. So now we are arresting a machine. Can machine commit a crime? Can machine be held liable for the crime it has committed? It is crime, of course, to buy drugs, and that too from the darknet. Another incident, 2018, the first victim of automated driven vehicles or automated driven car. Uber company was having an automated driven car, automatic car, self-driving vehicle. and a woman who was on the road, she was hit by that car, and pedestrian Elaine Hazelberg, she died due to the accident. Now, who is liable? Is it Uber who's liable? Is it the company Tesla which has made that vehicle liable? Or who else is liable? Similarly, you see, few days back, 2 years back, the Federal Trade Commission in United States fined Amazon Alexa, because what it was doing is it was collecting the voice samples of children. So therefore, without the consent, without the knowledge, and it was also collecting the locational data. Now that locational data was collected and used for data mining purposes, and therefore developing AI. And of course, it has been found, and they have been fined $25 million as a penalty. And if I go back around 45 years back in Japan, Kawasaki Heavy Industries, in 1981, the first incident where a worker was killed by a robot, an industrial worker who was trying to fix the robot, though he was liable to an extent because he did not observe safety protocols, he did not disconnect the cord, he jumped over the fence, those things apart. He was trying to repair the robot, and somehow robot, because it was not disconnected, because safety protocols were not on, because the cord was not connected, and because the parameter within which the human presence was not allowed, that was not followed, the robot did not rise, and it cut that person's head, choked that person against the safety gear, and the person got killed. 1981. So 45 years down the line, we are still wondering what is the liability regime. And have you imagined Alexa being a witness in court? I could find 3 cases at least of US, 2017, 2015, and 2019, where Alexa was treated as a victim, virtual witness, it's not victim, a witness, virtual witness by the police to, while it was investigating a murder case. If you see 2019 Florida murder case where Alexa was the data recorded by the Alexa, because it could record the voices, and therefore the voice identification was done by various softwares, including voice print studies. So therefore, the Alexa Echo Dot device was used to as a witness in a criminal case. Now, this is the background why we are here, why we are discussing that artificial intelligence based devices, artificial intelligence based softwares, if they commit a crime, or if they are called in as witnesses, or if they cause any injury, who would be held liable and how that liability can be fixed. That is the background why I thought this topic would be interesting. Before, if you are studying artificial intelligence, of course, I'm not here to define what is artificial intelligence. You people are better aware than I am what artificial intelligence can do. But then, of course, I will be briefly referring to the legal issues, the moral issues, the ethical issues concerned with the use of artificial intelligence, and the laws which are regulating the liability vis-a-vis the use of artificial intelligence machines. Before that, let us first introduce, let me know how much time I have at my disposal so that I can accordingly have the pace of my presentation. Yes, Gagan ma'am.
Excuse me, sir. We have time till 9, sir.
Okay, fine. Great. So I'm skipping this. Just one point that we understand, it has been labeled that artificial intelligence is the fourth industrial revolution, is data driven. And as we understand that AI is based on data, I have a few questions. Have you heard of Bob Dylan? Anyone? Bob Dylan? Anyone?
No, sir, we don't heard about it.
Okay, now there's a board diagram which is developed in London's Kingston University by Dr. Auden Ball, and what he has done is they have trained the artificial intelligence on the basis of 23,000 songs. So these 23,000 odd songs which are used to train that artificial intelligence, a bot known as bot diagram. Now this bot has understood the pattern of music, the lyrics which are being used, kind of music which is there in the folk music, and therefore it has created, it is now able to create music, and it is creating music which was hitherto left to the artist. We used to say that this is a great work of art and only the artist can do and only human intervention is required. Now this board diagram is creating music, the folk music. Now who will have the copyright? And if the music contains certain vulgar words or it creates enmity, I'll show the slide. Give me 5 minutes. I'm just discussing. Once I get back to the presentation, I will slowly show it. So now this board diagram is producing music, creating lyrics also. And if those lyrics create some sort of a music or some sort of words are being used which lead to hatred, you understand that many a times the songs are being challenged on the ground, that they are creating religious animosity or they are using sensitive words. So who would be liable? And whether this music can be copyrighted? What would be the rights? And if it is copyrightable, who would be the owner of that music? Would it be the chatbot? Would it be the software developer? Would it be the one who is using it? One who is giving the command, make a music? Because if I am giving the command, will I be the copyright owner? I'll show this slide, Sukhinderji, don't worry. Just wait. I'm not discussing anything. Once I discuss this slide, I'll show it. Yes. Who would be the copyright owner and who would be liable? That is the simple question. It's not a legal question. It is because there is no law as such as of today in India. UK has enacted a law. European Union has enacted a law in 2024, which came into effect on 1st of August 2024 only. It is still in the nascent stage, and even they are struggling. Even they are struggling to trace the. Okay. I get an answer. I don't think there would be any copyright in the AI generated things. And if I am able to demonstrate that I have given sufficient inputs and sufficient prompts, which are my creative ideas, and then AI has acted upon it, can we deny? Now I'll show this slide and then I'll come back to this question. Give me a minute. Now see, this is Sophia. Sophia is what we understand. It is the first award in the world which has been granted citizenship by Saudi Arabia. So now she is a citizen of Saudi Arabia. Hitherto, till 2017, the international law was saying, the domestic laws were saying that citizenship can be granted only to natural persons. And though, yes, there are some citizenship traits on juristic persons also, but it is the first humanoid, Sophia, which has been granted citizenship by Saudi Arabia. And therefore, if you see the legal regime in various countries, including the Saudi Arabian law, there was no provision as such that a humanoid can be granted a citizenship. Now the citizen commits some crime. And similarly, if you see in Japan, if you can see this chatbot Shibuya Mirai, this boy of 7 years on which this chatbot is based, it is granted a residence permit. So the residence permit Now it can stay. It will have in Japan. The Sophia will have all the rights which are available to a citizen in Saudi Arabia, and there are these circumstances. If AI, if that Sophia produces some music, Sophia commits a crime, Sophia commits a surgery, who is liable? That is the moot question with which we are grappled with. To answer the first question which was asked, which was answered by one of the participants as to that no copyright will be granted, it's a very complex situation, and it depends from jurisdiction to jurisdiction. In India, we can say yes, copyright may not be granted unless there are sufficient inputs, unless there are sufficient inputs, sufficient ideas given, and there is uniqueness in those ideas, there are new ideas. But then there are countries like US where they say derivative work. So there's an original work, and on the basis of original work, you might have derived a new work, and that work may be amenable to copyright. And if I go to Saudi Arabia, then the citizen can create a new work. Therefore, it may be copyrightable in Saudi Arabia or in Japan. So that is the background why we are discussing this. Before I go to the liability regime, let us briefly refer to the AI position, and then I'll come back to the principles governing the liability of AI. As we understand, it's a buzzword in today's world. If I see the report of McKinsey Global Institute, it says AI has the potential to add 16% to the GDP, world GDP. That is, it has the potential to add $13 trillion to the global economy. And therefore, by the end of 2033, it will boost global economy by $15.7 billion. And it is the reason that countries across the globe, including India, are preparing strategies to deal with and to regulate and to fix liability on the artificial intelligence regime. If I come back to the Asia, if you see China, it is estimated that 26% of GDP would be added by the artificial intelligence based technology by 2030. And in case of United Kingdom, it is estimated that it would add 10% to the GDP. So if you see world over, therefore there's no escape that artificial intelligence is going to be there. We cannot escape, and that is where we need to see whether the artificial intelligence can be regulated. If yes, what principles should be followed, and how would we as people would be affected. And if we see countries across the globe, whether it is US, whether it is France, whether it is Japan, China, United Kingdom, European Union, India, every country has come up with regulations. Every country has come up with guidelines. In India also, Canada was the first country who came up with the national AI strategy. India has also Niti Aayog in India in 2017 released a strategy on AI. And if you see, artificial intelligence have had an impact on every sector. Ukraine war, we are seeing laws, or what we call as lethal autonomous weapon systems. So lethal autonomous weapon systems, or maybe the drones, or maybe the humanoids which are used by Ukraine in the Russian-Ukraine war, they have been more lethal, more effective, much more effective than humans. And now if they are committing some war-related crimes, international humanitarian law crimes, the liability has to be fixed in the international law, which has still not been fixed. I was conducting some research on use of AI in healthcare, and therefore I tried to find out the usage of the regulation of the use of AI in the health industry. I tried to get the information from PGI, from the Directorate of Health and Medical and Health Sciences, but couldn't get any information. Then I lost in RTI with the Directorate of Health and Medical this. But then, to my utter surprise, the information received was that AI is not used in the government medical hospitals. Then I showed off an this RTI to the National Medical Council, to the in IMA, that whether the hospitals, private hospitals using AI in healthcare are registered and are they providing any data to the government, and nothing came out. Then I showed off an RTI to the municipalities, municipal corporations who are, or the civil hospitals who are required to register the hospitals as service providers. Even therefrom, no information could be gathered. But then when I visited many hospitals, some of my friends even, they are using AI, or their robotic surgeries are being done. Especially when we talk about prostate, robotic surgery is very, very successful. Knee transplant, we are using robotic surgery. And if you see in Ahmedabad, Dr. Tejas performed a cardiac surgery sitting 32 kilometers away from the place using the artificial intelligence and robots. And that means when we are talking about the key sectors, we understand education, agriculture, we were just listening to. So artificial intelligence is being used in law also. In my profession, we are using that in courts. We are using that in medicine. In predictive medicine, we are using artificial intelligence. We are using artificial intelligence in diagnostic, which is being used in USA for long now. But the question is, again, despite the AI being used world over, how would we regulate artificial intelligence? And here I will quote Will Knight, who wrote The Dark Secret at the Heart of AI, which was published in MIT Technology Review in 2017. He says, by its nature, deep learning is a particularly dark black box. You can't just look inside a deep neural network to see how it works. And that is where the situation becomes very, very challenging. So this is what I have already asked. So before I develop on the regulatory framework in India, as you can see from the screen, the regulatory framework is scattered. There's no single law in India which regulates the usage of AI, the registration for the purposes of use of AI, or the liability regime so far as artificial intelligence induced injuries are concerned. We do have many laws like MCI Act 2019, or maybe we have MeitY, Ministry of Electronics and Information Technology, regulations regarding data. We have digital data, personal data protection.
ये जो workshop
Yes, yes. Yes.
I think it was something accidental, sir. Please continue.
Okay. No problems. So, the Copyright Act. Now, even the Copyright Act does not talk about AI, but then Copyright Act can be used to regulate the copyrighted work. Patents Act, Contract Act, one of the most important laws. Contract Act, and that is where all of us would be affected. Whenever we use any app using AI, we give consents. You download an app on your mobiles, which is using artificial intelligence, which is collecting our locational data and then giving us recommendations that you do this, you do that. It is using our own data and we are giving the consent. I agree. You are clicking on I agree. Whenever you are downloading an app, whenever you are visiting a website, and therefore you are agreeing and giving consent. And once you give consent, there is a legally binding agreement between you and that website, that app. And most of the time, when you download an app on your mobile, it would say that give the permission to use your photographs, give the permission to use your call logs, to your emails, and we happily give our consent. Yes, which we keep on clicking, and therefore we are entering into click wrap agreements, as we call them, browser app agreements, as we call them, and therefore there is a legally binding agreement between you and the service provider, app developer, and therefore you have given the consent to use your data, to have access to your data, to use your data, and that data is used. for the purposes of making my virtual image, and then they will be making certain suggestions. And this data, as I said, in case of Washington 2023, they were storing that data. It was United States that they were able to the Federal Trade Commission was able to fix the responsibility of Amazon Prime, Amazon this Alexa. But in India, we couldn't find any judgment where they were able to fix the responsibility that Alexa has violated right to privacy. We understand that right to privacy is a fundamental right in India. After K.S. Puttaswamy judgment, the Supreme Court of India by 9-judge Constitution bench in 2017 declared right to privacy as a fundamental right. But then I'm myself giving the consent to use my data for and without seeing for what purpose this data is being used. And then the app is saying, do you give the permission to track my activity across other websites? Most of the time, we do not even bother to see, and we give the consent, and therefore legally binding agreement is created between us and the service provider. Then we can't say that our data has been used violating my right to privacy, because right to privacy I have to claim. So despite that there are various laws, one of the most important laws which would regulate the artificial intelligence tracking my data and therefore giving me recommendations would be Indian Contract Act of 1872. This apart, we have the intermediary guidelines. We have IT Act of 2000, especially Section 43A of that section, which says that each of the intermediaries and the service providers, they have to have reasonable security practices and procedures for protecting my personal sensitive data or information. We have also enacted 2021 rules. We have enacted various other rules. We have ART regulations 2021. ART is assistive reproductive technology. Of course, ART regulations of 2021 does not necessarily use the term AI, but it says if the assisted reproductive technology is being used for IVF purposes, and for IVF, any device, that device may be AI generated, that device may be using AI, or that device may be non-AI. If that is being used for IVF purposes, then that is subject to the regulations made under 2021 law. Niti Aayog has, of course, come up with certain regulations. Responsible AI 2021, that is the first piece of paper strategy which we find in India after 2017 white paper on AI, use of AI in India. And then in August 2021, the Niti Aayog again came up with operationalizing principle of responsible AI. But these are all guidelines. There is nothing so far as a clear mandate regarding use of AI is concerned. So that is where the law stands as of today. And it is in this context that we'll have to go through various doctrines to find out how do we fix the liability in case of artificial intelligence caused harm or artificial intelligence induced harm. Now, it is in this context, as I said, that if the car, there's a car, for example.
ಕವಿಯನ್ನು ಬರೆದವರು ಎ.ಕೆ. ರವೀಂದ್ರನ್ ಇಲ್ಲ
Kindly mute.
Somebody is talking, please mute.
Please mute yourself.
ರಚಿಸಿದರು ಬರೆದ ಕವಿ
It's Realme phone. Please mute yourself.
Realme RMX 3943, please mute yourself.
I think she has muted now.
Thank you.
No. Still it's on. Yes, now muted.
Can the host?
Now muted it. Now.
So you can start now.
सर आपका माइक म्यूट है।
It's unmuted now, sir.
Thank you so much. So if it is the harm caused is of civil nature, then the age-old, century-old law of torts, that would be used to determine the liability. Which says if there is a civil liability, if a person has suffered an injury, injuries that maybe he has lost, damage is caused to the property, or there's damage to the reputation, then we can use the civil liability principles, and that is where there can be fault liability or no fault liability. For example, as I said, the car is, there's an automated car. Automated car is being taken, we understand 3,000 odd accidents have been reported of these automated self-driven cars. Now that car causes damage to a shop which is on the corner of a road, and some financial loss is suffered, it's a civil liability. So in those cases, there are two different types of theories. One is fault liability, one is no fault liability. When we talk about fault liability, that means the party is at fault. And if you want to prove the fault liability, if you want to apply the fault liability theories, then you will have to prove that there was a negligence on the part of the party which caused the damage. And in order to prove negligence, you will have to prove that there was a duty of care. And how would you prove that duty of care so far as artificial intelligence generated things are concerned? For example, again, the doctor, as I said, has used artificial intelligence for predictive diagnostics. Now, AI for predictive diagnostics, as I said, they feed data, they use data mining, and then they say after 5 years, you might develop on the basis of your imaging. After 5 years, you may develop this kind of a disease, and they start giving you preventive medicines so that that disease does not develop. Now, in that case, again, it's a civil liability, and therefore we'll have to find out whether fault liability theory or no fault liability theory. The problem with fault liability theories are that you have to establish that the person who caused you the injury was at fault. He was negligent in the performance of duty. He had a duty and he has committed a breach of duty. And due to that breach of duty, some harm has been caused. But in case of AI-driven softwares or AI-driven products, it is very difficult to establish, because what duty of care? What care? Normally we say care of an ordinary prudent person. But when we talk about AI, can an ordinary prudent person imagine all the pros and cons of using an artificial intelligence induced robot or maybe some software? Answer, of course, is no. So therefore, you have to shift the standard of duty of care of an ordinary prudent person to duty of care of the standard of an expert. So the question is, how much duty of care, and how do you establish that the maker, that the software provider or the hardware provider has committed a breach of the duty? How we anticipate? We have to prove that there was insufficient data. The device was not well trained. The device was not trained to deal with these eventualities, and hence the data was biased. The many a time when we talk about again the copyright things, the data which is being mined, if that is copyrighted, in some jurisdictions, the AI, for example, when we talk about Europe, in Europe we do not allow even the AI to use the copyrighted material. So if I'm talking again about some inventions, some some copyrighted material contained in the form of articles or patents. What the AI had to do is, what the AI developing firm has to do is, they have to take consent so far as Europe is concerned. And they have to give due acknowledgement to every work which they have used, which of course is not a bad thing, which of course is very, very important if we have to protect the rights of people. But then it can be pretty time consuming, and it can also be very expensive. Transactional cost would be very high. But in case of US, it is what we say doctrine of fair use. So under doctrine of fair use, even the copyrighted material can be used. So now you see two different systems. If the AI developer has not trained the AI, has not trained that device, and the data sets are incomplete because he has not used the copyrighted material because he didn't want to increase its cost. Now, in that case, the solutions which that AI is giving, they cannot be proper solutions, and therefore they may cause harm. And therefore, you have to establish, and it is very, very difficult to establish in a civil court, that there was a duty of care, and therefore he has committed the data which that developer has used is insufficient data. That data is inconsistent data. There is bias in data, and hence the results are like this. So therefore, when we talk, and then you also have to prove that the harm is caused as a direct result of the breach of duty by the data provider, and that is where again I come back to that robotic surgeries and automated driven vehicles. Now let us suppose harm is caused. The patient is being operated upon. The cardiovascular surgeon is operating remotely using humanoids or robots. Now some harm is caused. Is it a negligence on the part of the service provider? Is it a negligence on the part of the doctor, or is it a contributory negligence? It's a very complicated question in legal jurisprudence. Service provider may be housed in country A, the hardware provider may be housed in country B, and doctor may be in country C. And therefore, filing suits against three persons housed in three different jurisdictions would be a very, very complex task. And it would be very, very, expensive also. And hence, and also not only this, as I said, even in case of automated driven vehicles, there may be a backup safety driver. Human intervention may be there. And therefore, the AI developer may shift the liability on the human intervention. Human, resource may say it is the fault of the AI, and therefore both are shifting the liability. And hence, what we say is that fault liability theories are not suitable so far as AI-driven resources are concerned, so far as the humanoids and robots are concerned. And therefore, we'll have to see whether we can fix the liability using no fault liability theories. And it is in this context that there are various doctrines again, which may be made use of. As I said, the European Artificial Intelligence Act 2024 is talking about strict liability, doctrine of strict liability. Now, if you see doctrine of strict liability, which has been developed in 18th century, that proceeds on the assumption that if you keep a kettle or if you keep a thing which is dangerous if it escapes, so if left without care, if left alone, it would be dangerous. So if you keep, for example, store water in a dam and that water escapes and causes injury to the nearby people. If you keep a dog and dog escapes and causes injury to the nearby people. Similarly, if in case of that Japan 1981 incident, now you keep that robot, and while operating that robot kills the worker. Now then we have evolved this doctrine of strict liability, that even if there is no fault, even if the water has escaped, not because of my fault, maybe because of act of God, there's no negligence though, yet the person who is having that resource, who is using that resource, the person who is performing that surgery, that hospital, that person would be liable on the basis, not on the basis of negligence, not on the basis of contributory negligence or any fault, but because of the doctrine of strict liability evolved way back in Ireland versus Fletcher in the Europe. So that doctrine of strict liability is being applied by the European Artificial Intelligence Act of 2024. But with passage of time in the last three centuries or this doctrine has developed several exceptions and hence is unsuitable for countries like India. Now, if you see doctrine of strict liability, that says if there is an act of God, if there is the thing which could not have been foreseen, unforeseeable thing happens, then you can't fix the liability on the person on the basis of strict liability, and therefore the courts in India evolved a new doctrine way back in gas leak case, what we MC Mehta case, doctrine of absolute liability. They said all those exceptions to doctrine of strict liability are not applicable, and if a person keeps a resource, or if a doctor if I apply that analogy to a car, to Tesla car, which is automatic car. So if a person keeps a car, uses that car and causes injury without any exception, that person is liable to compensate for any loss caused. So in India, so far as other torts are concerned, gas leaks are concerned, we have seen the Bhopal gas leak disaster. We have seen oleum gas leak in 1986 in Delhi also. So in those cases and in environmental degradation cases, the Supreme Court of India has invoked the doctrine of absolute liability in those tort liability matters. Same doctrine of absolute liability is claimed that it should apply even to artificial intelligence induced damages. So therefore, this is another theory which is applicable at present, or which can be applied at present. As I said, Europe is using the doctrine of strict liability. In India, it is a claim that doctrine of absolute liability should be used, which admits of no exceptions whatsoever, and says that any person who uses the resource, who keeps the resource, who if escapes, if left without care, can cause damages, can cause injuries, that person must be held accountable for the loss caused, whether he is at fault, whether he has taken reasonable care, whether he has taken sufficient measures to prevent his escape, yet that person is liable for compensating so far as the civil law is concerned. Then there's another theory, doctrine of vicarious liability. Now, vicarious liability, let us suppose now the doctor is working in a hospital. Hospital is using that device for prosthetic surgery. As I said, prostate surgeries in Delhi and nearby areas, now they are robotic surgeries and they are very, very successful. Now, doctor is using robotic surgery, and while performing that surgery, some injuries caused. Now, whether the doctor would be liable, he is an employee of a hospital, of a corporate hospital, or whether the hospital would be liable, that is where doctrine of vicarious liability that can be used. There's no such case that it is being used in India, but then it is being, many jurists, many legal experts, even Niti Aayog is considering. So they are saying that employer should be liable for the acts of the employee. So doctrine of vicarious liability says the employer is vicariously liable for the acts of the employee which are done in the course of his employment. So while a person is working for an employer, whatever loss is caused, employer must be held accountable, more so because he has the resources, more so because the person is working for him, for his profits and gains. And therefore, the primary liability would be of the employer. Of course, he can make efforts to recover that from the employee, but employer would also be liable, so that hospital would also be vicariously liable for the acts of its employees. So therefore, so far as the liability doctrines are concerned, principles are concerned, world over, the debate is going on whether fault liability theory should be applied, no fault liability should be applied. But European Union has made a beginning by applying the doctrine of strict liability. So far as criminal liability is concerned, again, there are various theories. There are, now after 2004, after the decision of the Supreme Court, Constitution Bench of the Supreme Court in Standard Chartered Bank, 2004, now we say a corporation can also be held criminal liability. Normally, to impose criminal liability, we say two things must be satisfied. One, an act or omission must be there, and two, there must be an intention to commit that act. That is why we say a child of 5 years cannot commit any offense, because he does not have the intention, the mens rea, to commit the crime. If you see McNaughton Rule of 1843, developed by Lord Coke way back in 1843, that if a person is insane and he commits a crime during that period of insanity, he does not have the intention to commit the crime, and hence he cannot be held liable. So to impose criminal liability upon a person, you must prove that there is an act or omission which resulted in the crime, which resulted in the act which is declared as a crime under the laws of that country. And number two, that act or omission was committed with the intention, the person had that intention. As I said, insanity is a defense. A child of 5 years or child cannot have any intention. And if the AI bot is being used as a security, as I said, Ukraine is using, it is reported that Ukraine is using robotic soldiers. So now if those soldiers are being deployed for protecting, for security purposes, and they commit, and they harm a person, some person is killed, or they fire inadvertently, or they fire because they are programmed to fire. So in that case, what liability can be imposed? Criminal liability, can it be imposed on the corporation, or will it be imposed on that? Direct liability would be imposed. These are the questions of criminal liability, not of civil liability. And that is where, as I said, in India, after 2004 in Standard Chartered Bank case, thereafter the decision of the Supreme Court, now we are saying even corporations can be held criminally liable. Earlier we were saying corporation cannot be held criminally liable because there's no natural person. The corporation is a legal entity. The company is a legal entity. If there is a punishment involved, punishment of imprisonment is involved, how would you punish the corporation? Now, after 2004, we have said just because the corporation cannot be imprisoned does not mean that it is not criminally liable for the criminal acts. So, of course, the criminal liability can be imposed upon the corporations, upon the firms, upon the hospitals. But then again, for imputation of criminal liability, we have to prove that there was some sort of intention in that corporation, in that AI device, that software, of committing the crime. So therefore, one of the theories which is being used, or which is being considered world over, is perpetration by others liability. That whatever is done, whether by the corporation or by its employees, or by the robots, humanoids, or AI devices, that for that the corporation should be criminally liable. Just like if a child of 5 years murders a person, and he was able to murder because the weapon was left by the father without reasonable care on a bed, and the child could get hold of that weapon, and he fired and a person is got killed. And therefore, there is a negligence on the part of the father, and why father should not be criminally liable for the act of the child. Like these days, when we are talking in traffic-related laws, we are saying if the minor is driving a vehicle, the vehicle will be forfeited and the fine would be imposed on the parents, because the crime is committed by the robot, but then the employer, the person in whose care that machine is, that person would be held liable for the acts committed by that machine. That is one theory which is being used in criminal law, not with reference to AI, but with reference to crimes committed by persons who do not have the intention, like crime committed by an insane person. If if what I do is I engage an insane person, somehow I lure him into, give him a gun, ask him to fire, that it's just a game and he kills someone, that the insane cannot be having an intention, he cannot be punished, but I can be. On the same analogy, it is being argued at the international level that criminal liability should be imputed on the developer, on the user of that artificial intelligence tools, if some crime is committed. As I said, in case of that 2015 Swiss, that random the chatbot which they developed. Now that chatbot purchased drugs from the dark web. So therefore, if we apply the perpetration by others liability, if the owner of that chatbot, who was that art gallery, who was giving a budget of $100, £100 to that chatbot, and that chatbot was buying drugs, buying other things, buying a fake Hungarian passport, so the owner of that could be held criminally liable. Though what happened in Switzerland was that chatbot was, of course, that tool, the entire machine was arrested, that was seized, confiscated, but after 3 months it was released on the ground that there was no intention to commit the crime, because the art gallery said we had a public interest in inciting debate on the point that these chatbots, these robots, these AI-induced machines can be used for committing crimes, and they can themselves be programmed to commit crimes. And in those cases, what should be the liability? And whatever drugs we have purchased, they are not meant for consumption. They were meant for display in the art gallery, just to tell people that this is how these machines or these AI-induced algorithms can be used. And therefore, after the owner of that art gallery was not arrested in Switzerland, and also the machines were released after 3 months, because they said there's no intention to commit the crime, and even the drugs were purchased just to entice public opinion that, number one, these drugs are available on dark web, number two, they can be purchased by anonymous person. So, but then it is argued, the critics of that decision of Switzerland, they're arguing that no, the perpetration by others liability theory should have been used, and the owner, that art gallery, should have been made criminally liable because they purchase the drugs, and purchase of drugs is a crime. Anyways, then is natural probable consequences. Now, if I am making a machine, I'm using data, and data is insufficient, data is biased. The other day, I understand that 1 year back, when the Prime Minister went and he said, I mean, show a picture with writing with the left hand and the AI generated right hand picture because of the insufficiency of data. So if the data is biased, data is insufficient, then the AI developer should be able to predict what would be the natural probable consequences if a command is given and the machine performs an entirely another act which leads to a loss. So natural probable consequence theory says that the AI developer should understand that if this kind of a command is given, what would be the natural consequence. Again, coming back to that Alexa 2020 episode. Now, that 10-year-old girl said, give me a dare. And Alexa did what? It had consumed the data of recent TikTok things, and there it has learned that dares can be given, that a person can be given dare that you touch this electrical equipment. And therefore, since the AI that Alexa had consumed that data, Alexa gave the child a dare that you just put that take that plug of the charger half out, switch on the button, and touch that exposed part with a coin, with a penny. Now, as per the natural probable consequence theory, that if such kind of a command is given, of course the child could be saved because mother cried from the back, no, Alexa, no, and she came to the rescue because child was not unattended, child was attended. Now, if you apply natural probable consequences theory, you would find that Amazon Alexa could be held liable for this, criminally liable if the child suffers some injury. Of course, as soon as the incident was reported, the Alexa was recalled and the issue was fixed, and therefore they took care that this kind of data is not given. But then, as he said, the AI is data driven. Since it is data driven, it will give answers based on what data it has been fed. But if the AI developer is able to foresee, or an expert is able to foresee that if this machine malfunctions, if this kind of a question is asked, what would be the natural answers, and if those natural answers constitute some offense, constitute some injury, then they should take adequate precautions to protect the natural probable consequences of any command given. And if they have not taken those measures, then the product developers or the software developer can be held liable. And then, of course, there can be direct liability which can be imputed. Direct kernel liability can be imputed upon the owner as well as on the person. Having said that, I must put on record that there are jurisdictional issues across the globe. When we say jurisdictional issues, that means one AI-driven thing, whatever machine you call it, the robotic humanoids which are used for robotic surgeries or predictive medicines, they are developed using different components from different countries. You may have a software from country A, you may have a product from country B, and therefore it would be very, very difficult to impute liability because there's no such international law where we say that you can file a suit in India and an Indian court can impose liability on the company in US or the company in Europe. And therefore, the jurisdictional issues so far as cyber world is concerned, so far as artificial intelligence world is concerned, that remains a big, big issue. There's another liability doctrine which is used so far as the civil liability is concerned in Europe. That is the PLD, Product Liability Directive of 2021, which has been recently reviewed in 2023. Now, PLD or Product Liability Doctrine, that imputes product liability. That means anyone who makes that product, and if that product malfunctions or results in a loss or injury, the developer, the manufacturer of that product would be held liable for civil losses, civil injuries caused by that product, regardless of whether there was any fault, any negligence. If the product is used in accordance with the prescriptions, in accordance with the guidelines issued by the product developers, and it causes a snag and it causes some injuries, then the product developer should be held liable on the basis of Product Liability Directive of the European Union. Again, if I take that to Tesla car, so one theory, as I said, no fault theory, is the person who owns that Tesla car, which is an automatic car, self-driven car, that person would be liable. No fault liability would say. Y'all would say you follow this strict liability doctrine. And then the person who has manufactured that, the company who has manufactured that vehicle or that robot, that company would be liable because it has supplied a product liability, product which is faulty. And in India, if you see Consumer Protection Act 2019, also talks about product liability. So the Product Liability Directive of European Union can be applied mutatis mutandis, can be adapted to apply even to AI generated things or AI generated softwares or bots, as the case may be. And the Consumer Protection Act of 2019 can also be used for imputing liability on the basis of a faulty product, and hence a doctor using some equipment which is using AI for detection, for prediction of medicine, or maybe for other purposes, he can say the product was faulty and therefore the liability can be imposed upon the firm, upon that manufacturer who has supplied that product on the basis of what we call as PLD, Product Liability Directive, or product liability, as the case may be. So these are some of the principles, and therefore there's another question Person has gone to the hospital. He wants to avail of the services of a doctor, and the doctor says, "Okay, fine, you need a surgery." So, doctor never informs the patient that the surgery would be performed by a bot. That prostate would be operated by a bot. He says, "Yes, we will do it." Person suffers the injury. Now the doctor says, "I did nothing. I did nothing." It is the machine which has malfunctioned. Maybe there was a voltage fluctuation or whatever, or maybe, as I said, AI is data driven, and if the data is insufficient, or if the data is biased, which this thing cannot be ruled out, then how would you I mean get through? How can you sue the doctor or the product supplier, or is it a product liability or a service liability? Again, availing of, are you a consumer of medical services, are you a consumer of services, or consumer of that product? So these are other complicated legal questions. Suffice it to say that, of course, in India, we have been using under the Consumer Protection Act the doctrine of strict liability as well as doctrine of absolute liability and the doctrine of product liability. And hence, if it could be proved that there was damage caused due to that product, then of course we can sue. The product liability can be enforced. But then the question would be whether software is a product. Answer is yes, software is also a product, and hence product liability can be imposed upon the developer, upon the service provider, and initial liability can be imposed on the doctor or on the hospital which is using that kind of device. So privacy is a very, very important right. As I said, after that Justice K.S. Puttaswamy judgment of 2017, the right to privacy has been declared to be a fundamental right, and AI has the potential to violate that right to privacy. Whatever I do on the net, whatever I search today, whenever I use whatever the commercial websites or apps, that data is compiled, that data is collated, and that data is used to make recommendations. And I was writing on right to be forgotten. Now, right to be forgotten has appeared as an important right in the European Union after that 2014 incident. Now, what happened? That there was a person who was prosecuted for tax evasion and labor law related matters. He was fined. He gave the fine. Thereafter, he found that whenever any person searches for his name, the Google is taking that person to all those clippings in the newspapers which were against him, that he has been prosecuted, he has been punished for tax evasion and other economic offenses. So he said, I've already paid the fine, and therefore I have right to rehabilitation. And he claimed that I have right to be forgotten. I may be allowed my name be deleted from all websites, including Google, and all those pages where the Google is taking whenever someone is typing my name out in the Google. Those redirections should be deleted, and he wanted that the direction be given to the Google. Of course, in 2014, European Court issued a directive that right to be forgotten is an important right. But then, when you apply these two, right to be forgotten and right to privacy, qua AI. Now, as I said, there are cases in India also when a person is a victim of a certain crime, be it rape or any other crime. Whenever you search the name, the entire data, AI would collate the entire data, and then on the first page, if you see on the Google, AI will give its perspective based on whatever data has been fed into it. Now, therefore, it is invading my right to privacy, and it is not allowing me to heal. It is not allowing my scars to heal. So, how I can protect myself against the violation of my right to privacy? If you have visited a particular site and you opens that somebody is opening your computer, the entire history is being shown, or you are giving those kind of recommendations. Or, as I said, a person who has been a victim whenever his name is searched, the entire bad things which are there on the YouTube or on other channels, they are being shown. So how do we protect our right to privacy, which is now a fundamental right, and how my data is protected? As I said, India has enacted Digital Data Protection Act in 2023, which would be implemented after October 2024. I'm saying would be. I'm using this word because it is the regulator yet to be appointed, though it was supposed to be appointed from 2024. So we have drafted the Digital Personal Data Protection Act of 2023, which has imposed liabilities upon the data principals, which has imposed liabilities on the data fiduciaries, on data subjects. But then, as I said, the act is in its nascent stage. It is still to be implemented. Till now, we don't have the boards have not framed the rules. The Digital Data Protection Board of India, it has not framed the rules, and the DPOs, the data protection officers, have not been appointed by the large corporates. As we understand, the data fiduciaries, that means those who are processing my data, the Facebooks, the WhatsApp, or maybe Googles, those who are processing my data, those data fiduciaries, they have not appointed data protection officers yet, because the law is yet to be implemented in letter and spirit. So therefore, this law, of course, is saying that these data fiduciaries must obtain a clear, specific, and informed consent before data can be used. And data should be used only for the purpose for which it has been obtained. It is the duty of those companies, those service providers, that data is not used for any other purpose. And for example, Aadhaar is a prime example. They are collecting my data, but that data can be used only for the purposes for which data has been collected. But then if you see DPDP Act, one of the stark realities is that DPDP Act has exempted the government and government instrumentalities from operation of the law. And therefore, government can demand data, can collect data, can collate data, compile it, and use it. The liabilities imposed upon the not on the government but on the private sector, that they will obtain clear, specific, informed consent before data is collected, and data shall be used only for the purposes for which it is being used. So therefore, it will have a dual, if you say, effect. One, if the AI does not have sufficient data to feed into, as I said, copyright regime I just discussed with you. If AI does not have the sufficient data or the appropriate data, then of course the results would be faulty. And therefore, if we allow AI to use even the copyrighted material without giving the credit to those who have worked, then it would violate the intellectual property rights of the persons who has generated that work. And therefore, it's a very, very tricky situation, which way to go. So far as the Indian DPDP Act is concerned, because Indian Parliament understood that AI is data driven and the data of individuals is required to be protected. That is why we have come up with DPDP Act. Of course, we have seen the European GDPR, General Data Protection Regime of the European Union. So we have seen that GDPR, which has worked very, very successfully since 2018. And therefore, we thought we can have our own DPDP Act. And now this DPDP Act is also talking about, in section 14, that if somebody says that the purpose has been accomplished for which the data was obtained, he can move an application before the DPO, Data Protection Officer of that organization, that my data be erased, because now I have got a right to be forgotten, a right to be let alone, a right to privacy, and therefore once the purpose for which the data has been obtained, this data should be erased. And once that kind of an application is made, the organization, that is the data fiduciary, which has obtained the data, again I'm saying this is not applicable to government institutions. It is applicable, they have carved out many exceptions so far as the public sector is concerned, the collection and compilation of data by government is concerned. But if I talk about Facebooks and WhatsApp and Googles, if they have kept my data, I can move that application to them that now the data which you collected is not required, the purpose hasn't been accomplished, and therefore you just erase that data. And if they do not erase, each of these organizations which is collecting data, which are data fiduciaries, they have been made duty bound to establish a redressal mechanism, grievance redressal mechanism, so that if my application has not been, taken care of, they have not acted on my application, then I can file an appeal before that grievance redressal mechanism, requesting them that, okay, my data be erased, or this data has been wrongly presented. So I'm not saying that we don't have any law. We have also made that duty bound that to protect this data, they should take reasonable security measures so that the data is safe. But having said that, we have seen in India as well as elsewhere that there are data leaks. Facebook data leak in European Union has been a big issue. Data leaks or Aadhaar data leak is a big issue, and therefore that data which is leaked, that can be used by the AI chatbots and others, and therefore my personal data could be available in the public domain, which can be used by the artificial intelligence based machines for making a digital image of mine. So what medicines I'm consuming, I'm ordering those medicines online, that data can be collated and that can be used without my consent. That is primarily the issue which I wish to discuss. I'm just keeping an eye on the watch. So just last few comments before I wind up and we take questions. So the legal jurisdictions across the globe, they are grappling with finding out a suitable liability regime and suitable preventive regime, that how we can grapple, how we can cope with the AI induced revolutions, and also protect the individuals against crimes, against injuries, and also how can we protect their rights, the right to privacy and other human rights. So that is where the entire debate, as I said, some steps are taken. India has taken some steps. European Union has taken some steps. The US has come with the various laws. France has come up with the sharenting law. So there are laws which are being developing. But one thing which I must say, laws always have a reactionary approach. Laws are enacted, especially in India, once a thing has happened and it has settled and now it has become a nuisance, then only we are then only we enact laws. We don't enact laws as a precautionary measure, we enact laws as a reactionary measure. And that is where probably this is a time for Indian Parliament that it should take proactive steps, not as a reactionary measure, but as a precautionary measure to regulate the AI regime and explore all possible avenues so that we can balance out the use of AI. As I said, AI is, it can't be unavoidable. But then the effort has to be that AI should be used as a responsible AI, as Niti Aayog is saying in its Feb 2021 and August 2021 papers, that it should be used for holistic development of the nation and the individuals, and it is not used as a tool to commit crimes and to harm the individuals. That is a little bit from my side. So now we are open to questions and discussions. I hope I have tried to finish within the time. Yes.
Thank you so much, sir. You have very well explained the concept of AI and liability regime by highlighting that AI robots are getting citizenships, and
Thank you.
you have highlighted that AI has impact on lethal autonomous weapon system and IHL, defense, industry, trade, agriculture, education, intellectual property, and service sector covering healthcare, financial technology, legal profession, IT, transport, etc. You have very well explained the regulatory framework of AI, like responsibility AI, 2020-21, Operationalizing Principle of Responsible AI 2021, Telemedicine Practice Guidelines 2020, IT Reasonable Security Practices and Procedures Sensitive Personal Data Information Rules 2021, etc. You have highlighted that civil liability and criminal liability principles can be used for the wrongdoings done under AI. You have pointed out that no fault liability can be raised against AI under doctrine of strict liability and doctrine of absolute liability, and employer liability can be raised for the wrongdoings done by the due to the mistake of employee under doctrine of vicarious liability. You have also pointed out that Shri Krishna Committee had pointed the legal framework is essential in India to shape the global digital landscape within in the 21st century, and the dire need to consider sectoral approach of US while drafting the legal framework. Thank you so much, sir, for enlightening us all about the usage of AI and the legal framework. Thank you so much, sir.
Thank you so much. Thank you. Thank you, everyone.
Sir, I think you have. It was a treat to listening to you, and you have. We are dealing with data. We are, somewhat aware of AI, but the scenarios you have, made us aware. Like we're not aware about the legal implications and how the country is moving towards the privacy and all other things. So I just wanted to have a question. Like you told about that AI is being used in healthcare for precision medicine and diagnosis. So there are some principles which are being followed worldwide. There are some, the protocols to be followed, very strict protocols which clinician follows while recommending, any genomic-based testing, for example, for cancer and other diseases. Okay.
Yes.
And what is your experience in India? How India data policy is, taking that aspect into consideration?
So let me put across my personal experience first. As I told you that I was doing some assignment on use of AI in health sector. I found some interesting things, and then I thought one of my candidates is now doing a PhD on use of AI in health sector and legal regulation of the same. So we thought let us collect some data. So as I told you, we approached one and all. We have approached everyone in the government sector, and they don't have any data on the use of AI in the healthcare. So far as Punjab is concerned, I'm not saying the center. So far as Punjab is concerned, they don't even have the number of hospitals which are using this robotic surgery. For example, they don't have the number of hospitals or clinics which are using telemedicine surgery. They don't have any data. Neither that data is with the National Medical Council, nor that data is with the municipal authorities, civil hospitals which are registering the hospitals. That data is not available at, so far as the government hospitals are saying, they are saying no. Director General of Health and Medical Sciences is saying we don't keep that data for whatever reasons, I don't know. So the point is, that is what I am saying. If unless you have the data regarding the usage of AI, you can't. You can't reap the benefits of AI. You can't transplant the findings of one system in India. So we did. I was giving a lecture somewhere. I said, let us suppose all 8 of you belong to X, Y, Z, ABC countries, and I ask a question from AI, and I give entire data to the AI, and then I ask a question from AI, what is alpha? AI will not be able to give me answer. It will give me a wrong answer because it has not consumed that data. So therefore, data localization principle is very, very important. That while we are having AI solutions, it should be based on local data. But when the local data is not available and you are using the transplanted data, how would that data help? And that's what I understand is, so far as my experience is, that data in India, we are lacking data. We don't have that data. That is one thing. Very, very scarce data. Most of the institutions are not having. Number one. Number two, when I tried to ask the private, hospitals, we went to Fortis. Let me confess, we went to Fortis. We went to other private hospitals, Park Hospital, and we asked them, okay, can you give us the number of cases where you have used robotic surgeries? What kind of problems you are facing? They were not willing to talk. they were very, very hesitant in discussing, because they say, okay, fine, there are patient confidentiality and privacy concerns. So they use that confidentiality and privacy concerns not as a right of the patient, but because they didn't want to share the data. So I think one of the biggest problems in India is data. How we can have the AI solutions based on local data, number one, and number two, data management systems. We don't have data management systems in majority of the health sector so far as Punjab is concerned. I don't know about Delhi and Bangalore. We have been able just to see the Punjab region. We have decided that we'll see Gurgaon and NCR region, Gurgaon, Delhi, Noida region also, to find out what are the practices which they are following. So far as the ICMR is concerned, it has issued guidelines. Of course, NMC has also issued guidelines, but then there is hardly much compliance mechanism there also. That's what my response is.
Thank you very much, sir. I really surprised to see that you approached so many hospitals, particularly for robotic surgery, and you can see, the hoardings, the banners, many hospitals claiming to be very expert in robotic surgery. So this is
And the civil hospital and DGMS says we don't have any data.
So, excuse me, sir, I have a question.
Yes, please.
Sir, can AI be considered as a personality, as another corporate personality, just as we have companies, and then fix the liability? Can it be
Yes,
the
that's
case?
what I said. If it can be, AI can be issued citizenship. As I said, Saudi Arabia, Riyadh, they conferred citizenship on Sophia. Japan has conferred that work permit or residence permit to Shibuya Murai, the boy Shibuya Murai. Now you see, if we are, that is where the traditional notion of this entity, or maybe corporate personality, that has shifted now. So now we are moving towards giving this citizenship and this corporate personality even to the chatbots, or even to the humanoids. You see, if you just search on the web, the Sophia is being interviewed. She is going and giving lectures. So that is why they have given citizenship to Sophia. But then, so far as India is concerned, we do not have any such case where citizenship or even the corporate personality is given or is conferred on a chatbot or on AI thing. But yes, beginning has been made. As I said, Saudi Arabia made the beginning way back in 2017. It's been 8 years now.
Of course, then liability can be fixed.
Yes, of course. Now there's a citizen, so citizen can be given rights as well as liabilities.
Thank you so much, sir. Thank you.
I think if there are no more any questions, we can conclude, Dr. Jaspreet.
Yeah, thank you so much, sir, for your valuable time and wonderful session that you have delivered on artificial intelligence. We are so grateful to you for sparing your precious time, and we will be hearing you in the next session also. You are having another session with us. So thank you so much, everyone. Thank you so much, sir.
Thank you. Thank you so much.
See you tomorrow. Thank you, sir. Thank you so much.